Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments because I'm here to answer your questions. I have a great topic to talk to you about tonight. It's going to be applying for the provisional unlawful presence waiver. What is that? That's what we'll start with. So when you are here in the United States, there are certain individuals that are stuck here. You can't stay here and apply for permanent residence through adjustment of status because you just don't fall within a category that qualifies you. Then you must also leave the country and finish your process at the embassy in your country. But the problem is if you leave the United States to pursue your green card at the embassy in your country, what will happen is that you will be barred from coming back to the United States because you've already overstayed and accrued unlawful presence. Once you overstay your legal status by more than 180 days, you will then be barred from getting any green card, any visa, re-entry into the United States for 3 years. If you overstay over 1 year, that turns into a 10-year bar. So what happens is that there are certain individuals that they're here, they're unable to stay and they're unable to go and they're stuck. However, there is a solution to this if you qualify. Now, to qualify for this, you'll have to have a U.S. citizen or legal permanent resident, spouse, or parent who will experience extreme hardship if you don't get permanent residence. So I know that's a mouthful to take in, but I'm going to break this down for you. So the first is if you have a U.S. citizen or legal permanent resident, spouse, or parent, and you are unable to stay, you're unable to go, you should explore your options here with me in a consultation because I can then go through your facts to determine whether you qualify. In this case, the first thing I do is determine whether you have a qualifying relative to get forgiveness. Then after I determine that you do have a U.S. citizen or legal permanent resident spouse or parent, the next step I ask is, will they experience extreme hardship if you don't get permanent residence? What does that mean exactly? Now, when I talk about extreme hardship, what I'm talking about here is if you're, and I'm going to give you examples, right? But I often ask this, will your spouse or your parent that's here in the United States, will they experience devastating consequences if you don't get status in the United States? If your answer is yes, and you can think of certain consequences that will take place if you don't get the green card, then you may qualify for this. Now, let me give you some examples of extreme hardships. So, for example, if you're here, you're living with your parent, and your parent is dependent on you. If your parent, they're experiencing health issues, they need you to be there for them, to help them make decisions, to take care of them, to take care of the household. Then if you leave, they're going to be in trouble. They're going to face detrimental health consequences if you leave. And they're unable to relocate to your home country because you may have limited resources in your country for the kind of care they're going to need. You may have, they may be targets in your country. They may not have insurance or benefits available to them to help them with their health issues. Then in a case like that, this would be considered an extreme hardship. And based on that extreme hardship, you could possibly get forgiveness for the unlawful presence, and which would allow you to then go to your home country when the interview is scheduled to get your immigrant visa and quickly come back to the United States within weeks. Now, the provisional unlawful presence doesn't allow you to stay for the entire process in the US, but it's the next best thing when you don't have many options. What it does allow you to do is you can stay in the United States while your relative petition, your relative or the employer petitions for you. You can stay in the United States while you get a decision on the waiver, on the petition, then you can apply for the waiver and wait for a decision on the waiver. When you do, and then at that point, you can wait in the United States until your interview is scheduled at the embassy. At the point that your interview is scheduled, you can then attend the interview. So go down just in time for the interview and then come back within weeks after getting your immigrant visa. When you go to the interview, as long as unlawful presence is your only immigration violation, you would be, it's a safe bet that you would be able to come back within weeks. And so that unlawful presence will not be held against you. That is the purpose of this provisional unlawful presence waiver. Now, I'm also here to answer your U.S. immigration related questions. So by all means, feel comfortable to put your questions in the comments. I'm both on YouTube and I'm on Instagram. So put those questions in the comments. I will answer your questions. So I'm going to go through some incoming questions that I see here. What's the first step for an overstayed visa waiver to get status? So Flawless 12, this is a very relevant question, and the first step would be for your relative or your employer to file the petition. Once you get a decision on the petition, you can then use that approval notice from the petition to file with the provisional unlawful presence waiver. Now, I do help my clients with this, so schedule a consultation. There is a scheduling coordinator who's available up until 10:30 p.m. to answer your call, schedule that consultation. You can also schedule your own appointment by going to the link in my profile, and you'll see a button just there for you to schedule your appointment. So is it difficult for a teacher on H-1B to get a green card? So Jamaican Lisa, there is no direct path from an H-1B to a green card. You're still going to have to be qualified through an employer. You're going to have to qualify through a family member. And so how difficult or how complex it's going to be is going to depend on how you qualify. If you would like to evaluate your particular options, always feel free to schedule an appointment, because the information I'm giving is general information, so you want to make sure that you get specific legal advice. The 2-year rule does not apply. So cabs, font size, I'm not sure here what you're referring to. Okay, so I see you here now. So would it be an issue if I do it while in the US after completing the J1 and then the 2 years don't apply? I wouldn't be able to answer that until I evaluate your particular case. If the 2-year foreign residency requirement doesn't apply, then and that's what you have to be very careful about. But if you're sure that it does not apply, then you're able to, you won't have any restrictions and you may be able to adjust status. But I would have to evaluate all your circumstances because remember, only certain individuals qualify to adjust status. Not everyone who qualifies for permanent residence is going to qualify to stay and apply for a green card in the United States through adjustment of status. So very important that you schedule a consultation, cabs, font size, and then get legal representation, especially when you're dealing with the J1. There's no direct path from J1 to green card, but of course, if you qualify through an employer, through family or other means, then you could possibly have a path. The I-485 interview was completed and the case must be reviewed. Is it good news? How long does it take? So it depends. So it must be reviewed. Sometimes at the interview, at least most times, we get a decision at the interview. So if the case must be reviewed, it may be that you submitted evidence at the interview that they have to first review before making a decision. So I don't know your case. I'm not the attorney on your case. The only way I'd be able to tell you if that's good news or bad news is if I actually prepared your application or reviewed your application. I did not, so I can't tell you whether this is great news or bad news. Sometimes it does happen. Sometimes it leads to a more complicated case, and sometimes it goes through just fine. So you'll have to keep an eye on your case. If I overstay my H-2B visa, can my sister give me adjustment of status? So Jasmine, it's likely not going to happen that way. Your sister, the reason your sister wouldn't be a path to adjustment of status is because in order to apply for adjustment of status, you would have to, unless you're the immediate relative of a U.S. citizen, and that does not include the sibling of a U.S. citizen, you would have to maintain legal status. You'd have to have an approved I-130 with a prior and current immigrant visa number. In this case, because to get an immigrant visa number, it's taking a minimum of 14 years. It's unlikely that you would be able to maintain your legal status for 14 years while you wait for an immigrant visa number to become available. So you would have to, if you're looking at just your sister to sponsor you, in this case, and keep in mind, I'm not your attorney, I haven't evaluated all your options, but when it comes to onto a U.S. sibling sponsoring their sibling, it's unlikely that they'll be able to do adjustment of status if they don't meet all the conditions, which is going to be, you can't be overstaying your status at the time you're applying for adjustment of status. Is it true that Florida State professed green card application outside the U.S. quicker than other states? So no, it's not true. My brother overstayed on his B1, and my parents have to renew their visa 10 years B1 next year. Will it affect them? So it depends. I mean, if they are, if they're renewing their status is totally unrelated to your brother, it may not, but, or if they're implicated in some sort of wrongdoing, then it may. It just depends on the facts here. I wouldn't be able to answer that because I don't know what the situation is. I don't know if there are specific concerns. So, it would all depend here. All right. So keep those questions coming. I'm going to break down it's called the provisional unlawful presence waiver for you. So this is a situation where you can't stay and apply for permanent residence, and you can't leave, because if you leave, you will face a bar of at least 3 years, which can go up to 10 years and complicate your case once you're outside of the United States. What can you do in this case? Now, there is one way to fix your status. There may be other options too. Keep in mind, this is not the only option. But whether any one of these options are going to fit you, it's going to really come down to your facts. That's where doing a personal consultation is very important. Tonight, I'm talking about how to fix your situation with this I-601A provisional unlawful presence waiver. It is the forgiveness for overstaying and accruing unlawful presence. When you overstay over 180 days, if you leave the country, you will get a bar of 3 years. If you overstay over a year, that turns into a 10-year bar. So before you leave the country, you have to make sure you get this waiver approved. Now, at the point you stay here, your spouse, your employer, your parent, anybody else who qualifies to petition for you can petition for you. Once that petition is approved, you can then apply for the waiver. Once you get an approval on that waiver, you can then take that approved, wait again in the U.S., wait on your interview to be scheduled at at the embassy in the foreign country. When it has been scheduled, you can go down there a few weeks to prepare for your interview. Once you attend your interview, the unlawful presence will not be held against you. And that is because that's the whole point of the provisional unlawful presence waiver. Is there to give you forgiveness to travel outside of the U.S., to get your immigrant visa to come back to the U.S. Within weeks after you attend the interview, you would be able to get your immigrant visa and fly back to the United States, and you would be your problem would be solved. Now, once you get to the point with my clients, I make sure that they're okay to do this process, because here are the downsides. So the first is that while you're waiting in the US, it doesn't necessarily grant you any particular benefits to be here, like a work permit. The other downside is, hi there, Dark Horse. The other downside of this is that it's the other downside of this process is that if you have any other immigration violations, then this will not work for you. You only have to have unlawful presence. If you have, for example, a criminal issue that has rendered you inadmissible, past misrepresentation or fraud, or any other violations that are going to render you inadmissible, then you're going to have to pursue another path. However, if you just came, you ended up overstaying, accruing unlawful presence, then this is going to be the process for you. It's the solution here when you can't stay and you can't go. Now, remember, to qualify for this, you have to have a U.S. citizen or legal permanent resident, spouse or parent who will experience extreme hardship if you don't get the status. What does all of that mean? So extreme hardship is, I like to explain it this way. If you're a U.S. citizen or legal permanent resident, spouse or parent, and keep in mind, though, they don't have to be the petitioners. They just have to be the ones that you're showing will experience extreme hardship to get this waiver. It could be an employer that's sponsoring you or someone else that's sponsoring you to get this waiver. But if you can prove that they will experience extreme hardship, as in something devastating will happen in their own lives that will affect them in a very, very negative way, if you don't get to stay here, or if they have to go with you and move to your home country with you, then this waiver would be for you. I mentioned before, if you're the caretaker, the only caretaker of your parent, the only trustworthy person for your parent, that could be one way. And also, if you, for your example, your spouse, if you have children together, if your spouse has employment opportunities, if your spouse will be left with all the debt, if your spouse will need your help to live in the United States but won't be able to get it if you don't get status, these are examples of extreme hardship. Now keep in mind, these are just examples. It really comes down, it's very fact-based, and it depends on what's going on in your situation for me to determine whether these could qualify as extreme hardship. All right, so I'm gonna go through questions here. So Crazy Beautiful, hi, I got my interview scheduled. I'm super nervous. I understand. It is a nerve-wracking process. You do have a lot at stake, but Crazy Beautiful, make sure you prepare, make sure you follow the instructions in your notice. If this is marriage-based, make sure you prepare with your spouse, review your application, know what's in your application that you submitted, and then just go in, relax, and be yourself. Okay, so, oh no, he came and overstayed, and their B1 is close to expiring and they have to renew it. They didn't know he was going to overstay. Okay, so if he's facing an issue, he should definitely get some legal advice. What's the cost for consultation? What's the cost to adjust from J1 to green card holder? So what I can tell you is the cost for the consultation is up to $150 for up to 1 hour. In that time, I evaluate your case in detail. I provide you the legal advice that you need to understand your options to avoid mistakes. and I also offer representation. It's at the point that I determine what kind of case you have and whether you qualify that I provide you the code for my flat fees to represent you. What can my husband and I do to tie us together? We do not rent our house. It is in his business name, health insurance. So Tammy Weiner, that's where you definitely have to make sure you get legal advice and representation. Don't underestimate this process. Make sure you get legal advice about how to move forward with your process. This is your future with your spouse in the United States. Make sure you take all the steps to get it right the first time, so you're not facing the trauma and the trauma of going through a bad marriage-based green card process. What I can tell you is that I know you're listing some of the circumstances here, but as a married couple that's living together, you will be able to find that evidence. You just have to get the right guidance and representation. So go ahead, schedule a consultation, and I can evaluate your case in further detail. So I'm asking because I'm on 2-year green card and want to renew too. So Tammy, schedule a consultation and we'll talk for sure. Advanced parole, VAWA approved, will let me in when I enter the US after overstayed more than a year. So if you have advanced, Anthony Lazario, once you have the advanced parole, that's a travel document, and your VAWA is approved, that is what that document is there for. However, keep in mind, I'm not your attorney. I don't know your circumstances, because remember that whether or not there is that small risk that and they say it, if you notice, they have that disclaimer that when you're coming back into the country, there is that small risk that you may not, the officer reserves the right to deny you entry, even though the document is there to let you in. And so to make sure you're not one of those that are going to end up facing a bigger risk than you should get legal advice through your process. Because I don't know your situation. I don't know what's going on in your case. That would make me advise you not to travel. So keep that in mind. But usually when you do have the travel document, that's what it's there for. It's for the purpose of allowing you to travel. So VSPR, I'm in Boca Raton, Florida. However, I represent clients all over the United States, in all 50 states and the globe. So it doesn't matter where you are. It doesn't matter where I am. I can represent you through your immigration process as long as that's what your issue is. So go ahead, go to the link in my bio. You're able to schedule your own appointment, or you can call. There's a scheduling coordinator who is going to be available for 1 more hour to speak with you, help you through confirming your appointment with me. Make sure you do that, because this is your future here. You want to make sure you get it right. This is the investment. So don't underestimate this process. Make sure that you fully understand what you're getting into and how to ensure a smoother process. All right, so that is going to be it for me tonight. Thank you. I enjoyed your questions. Thanks for joining me and spending the time, your Friday night with me. I hope you're looking forward to a cozy, warm weekend. I'm here in Florida, but we are now looking at a cold weekend. So I hope wherever you are in the United States, especially if you're up where all the winter storms are going to hit, that you stay warm, you stay safe, and go ahead, schedule the consultation so we can get started on your case. You are welcome. For those of you who asked your questions, thank you for that. Have a good night. Now, one thing also, I'm heading on over to Instagram. So if you want to continue asking questions, you can hop on over there. Also, most of my content is there. I do lives every night on TikTok, and I do lives on YouTube. but I release videos on YouTube and Instagram regularly. So you can go to either YouTube at The Immigration Attorney or Instagram at The Immigration Attorney, the same as here, and join me there in a minute to continue to ask questions. Have a good night. Bye-bye.